Alright, today I decided we're going to look at something. This is a copy of the letter I wrote from inside Southern Regional Jail to the members of the West Virginia Bar Association, which is a written complaint on my previous attorney, Mingo Winters. Now, this goes down to not only a breakdown in communications. I'm accusing him of being part of an organized criminal enterprise under West Virginia Code 61-13-2 and West Virginia Code 61-13-3, subsection A, and 61-13-3, subsection C. Now, I should point out that there's a whole mention of the falsified evidence and everything else that occurred last time in the previous case. And that my issues with Winters is that, one, Mingo Winters does not want to address the arresting officer's use of false statements and concealing evidence. Refusal and excuses concerning getting a subpoena to get my phone records, which is exculpatory evidence. Refusal and excuses to file a subpoena to get a copy of files from my laptops taken under false pretenses that contain exculpatory evidence. Exculpatory evidence is what, proves your innocence. Refusal and excuses to show a history of false statements, harassment, special favors, and abuse of power by both my accusers and troopers of the West Virginia State Police Detachment 6. That's out there behind the armory with the DMV. 5, intentionally creating a breach of trust and a breakdown in communication to attempt to conceal his refusals to protect my rights and properly defend me in court. Oh, and here we have included in the statement is a CD that was supposed to be sent out, but apparently the people had burning it for me didn't quite get it off all that well. My number from Southern Regional, and the address for Southern Regional Jail. And my mailing address, as well as the official seal of notary and the mention from Southern Regional Jail. Now, that kind of sucks, so I'm going to point something out. This is a certificate of service for the 25th of October 2011. This is a day before the second search warrant was filed. The second search warrant was filed by Trooper Efred the 26th of October 2011. This went directly to Christine Keller. Now here's something that's important. I want to show you this. Actually, hold on, before I do that. This is the actual motion in and of itself as received in magistrate court. And there's the stamp right here. The motion to compel to get that information from the prosecutor's office. Oh, and here we see Mingo Winters. Now this is what happened. This was the result of this whole thing. Mr. Winters, apparently, after it was received in magistrate court, we never went to magistrate court. We never argued it in court. He simply went with what the prosecutor agreed to. What the prosecutor agreed to, here it is on the 26th of October. So maybe there's a correlation between Mingo Winters, the prosecutor, and Trooper Efred taking the evidence out of the forensics lab. But this is what we get. All phone numbers of the alleged victim and her family members 2009 to present, because Ashley was using other people's phones. No, just her mother's. What? Why? Wait. Here we go. All defendants' computers previously seized by the West Virginia State Police as they contain possible exculpatory evidence. No, we never went to court to argue that matter. I know I was never given a summons to court. There is no record on court for that. It was just pushed on through. That's amazing. The prosecutor said no, and my attorney just said, okay, whatever you want to give me. Oh, here we go. A list of all places the alleged victim has been employed since 2009. That's key because Ashley actually talked to one of my my best friend at a bond revocation hearing and found out that his aunt/stepmother was working at Morgan's, and so she gets a job at Quality Inn. And I know this because Jessica Lilly actually let me take a shot of the screen to show that she was, of Ashley's MySpace, to show me that she was working at Quality Inn. So why does a girl from Grandview in Beaver, West Virginia get a job on Harper Road, knowing I was living in Harper Heights at Quality Inn, the place where my best friend's stepmother works. Unless, of course, she thought she was going to try to get me to come by to visit or something and then claim stalking again. And here we see this all comes down to Mingo Winners. It doesn't matter. This is an official court document. We never went to court. There was no court hearing for this. On the 26th, the day that the second search warrant was obtained in Kanawha County to take my computers back out of the forensics lab, the prosecutor says no. They tell my attorney what he is allowed to have. That's a judge's decision. That's a judge's job. It is up to the judge over top the case, or the magistrate over top the case, in this case, Magistrate Jones, to hear these motions beforehand. But instead of simply actually, hearing the motions, the prosecutor says, no, you can have this, and you can have that, and we won't give you this, and we'll give you that, and you can only have this, but only to a certain limited extent. So the question comes down to, why in the world would they be in such fear of having all their phone records exposed? Unless Ashley was using another phone other than her mother's to contact me since 2009. Actually, early 2009. But it doesn't matter. See, the fact of the matter is, there's enough here to call into question what's really going on, combined with Pat Lamb's whole thing about transferring the case in front of Hutchison without ever mentioning it to us. Seems like they're trying to cover some stuff up here, doesn't it? Even the simple fact that my lawyer went through the motion, or the motions, of attempting to look like he's doing something by filing a motion to compel, but never actually having it heard in court. That makes me question the morals and integrity of not only the Raleigh County Prosecutor's Office, but whether or not they are actually and truthfully involved in a criminal conspiracy as part of organized crime, as well as Mingo Winners, based on circumstantial facts and evidence, to railroad people through court, knowing that they are falsely accused. What could they have to gain from this? Makes you wonder. Another really, really interesting and important fact of this that I just have to address is that now that it's out there in the public eye and everyone knows it, not only that, there's that whole pesky thing with me having to go in front of Judge Kirkpatrick myself because my attorney became suddenly sick, and the prosecutor having that evidence I mentioned, the recordings of me and Lieutenant Deeds and Captain White for professional standards, and oh God, so much other stuff. This is just more fuel on the fire. It makes me come into question something here very, very soundly. What's really going on? What is the lawful authority you're claiming? Because right now there's enough evidence on the table to say you don't have any. That badge is nothing but a piece of tin. That judge's robe is nothing but a piece of cloth. That prosecutor's office is nothing more than a place to file paperwork, to kidnap, harass, and imprison people falsely, to charge them for crimes they did not commit. And the only thing you're dependent upon is a few dirty cops with guns who want to hide behind lawful authority. Oh, that also breaks into that whole little thing under not just the federal codes of 18 U.S.C. 241 and 18 U.S.C. 242, deprivation of civil rights under color of law and conspiracy to deprive a person of civil rights under color of law, but there's also an 18 U.S.C. 245, which is criminal acts taken under color of law. And that's exactly the realm we're getting into. And that just adds on to the additional criminal acts you're already putting forth. See, you're not the big shark. I'm not the big shark. The feds, now they're the big shark. And I'm smart enough to know I throw enough chum in the water, I challenge enough of the status quo, I show enough of the dirty deeds. Well, the more you run from it, the more you prove me right, the more everyone sees it, the more we all know about it. And it's not just West Virginia watching. It's not just the U.S., the whole world. World Wide Web and all that. See, The whole point is to make you run. It's to make you show fear. To watch you dodge and dodge and dodge. Same way that Trooper Moore kept dodging and dodging everything, because there's that whole missing 26 days of evidence. Because there's a hole through the evidence big enough to drive a truck through. We all know it. You can only duck and dodge for so long, and then after that. So here's what happens. You can postpone the felony charges 3 times before you have to dismiss them. But the misdemeanors ones that are attached to it, you only got 1 more. Well, since it's all one big case, maybe you only have 3 more out of that. But here's the thing about it. You have until 20 days before court to give me the evidence I request, to give me the motion of discovery. So if we push it back, I only want it pushed back 30 days. That gives you 10 days to get the evidence, to give it to me, and 20 days before court. So you have a very limited amount of time. And then there's that whole issue with everything put out here on public record. See, anyone who's had bingo winners, you now have evidence of him acting inappropriately and criminally and unethically right here in the public view. This is actually usable under law, under West Virginia Rules of Evidence, specifically Rule 1005. And all of the West Virginia rules dealing with behavior and patterns of behavior, which is Rules 404, 405, and 406. Feel free to look those up. They're on the internet. So what it means is, according to the West Virginia Rules of Evidence, if you want to appeal your case because you feel Winters didn't do a job for you, or if you want to sue Winters because you feel he's not doing his job properly, or if you want to file a complaint on him with the Bar Association, you now have evidence in the public view. You just got to link it to this video. Bye-bye now.